Good afternoon, everyone. My name is Haley Shanoff. I'm the Communications and Issues Management Advisor here at the college. And thank you for joining us today for this educational session, The Life Cycle of a Complaint, in conversation with the Professional Conduct Department over here. And I'm joined in this conversation by two members of our Professional Conduct Department. We have Beth and Emmett. So thanks to you both for being here. So just before we begin the session, I want to provide a little bit of context as to why we decided to hold this conversation. So within our public protection mandate, one of the college's key responsibilities is to address concerns about the professional conduct of registrants. And this work in part happens through our complaints process, which plays a crucial role in ensuring public trust in the professions. I do also want to mention that most registrants never face complaints during their careers. However, these processes can feel very daunting if and when they do arise. And we do receive a lot of inquiries from registrants who are concerned that a complaint might be filed against them, as well as questions from registrants who are going through, who are the subject of a complaint. So we're just hoping that this session will alleviate some of the concerns and provide some helpful information to registrants on our processes. And another note that during our conversation, you'll hear Beth and Emmett referring to the Complaints Committee. They're going to be talking about the committee's role, but I wanted to just ensure that everybody knew, everyone who's watching knows what they mean when they say Complaints Committee. So the Complaints Committee is made up of members of the college's council. And if you're not aware of the college's council's role, they are our, that's hard to say, governing body and board of directors that manages and administers the college affairs. So council members consist of social workers and social service workers who are elected by the other registrants who live and work in their communities to serve on council, as well as members of the public that are appointed by the Ontario government. So that's just sort of a little background on who they are when you hear Beth and Emmett referring to this committee. After our conversation, we're going to go and into a few scenarios for discussion. We're going to be using Mentimeter for audience participation. So that's the same site we were using this morning in the feature presentation. For those of you who tuned in for that, we'll put up information on the screen as to how to join later on in the session. Yeah, so with all that being said, we can get started with our conversation. So I'm going to ask Beth our first question. So this session is focused on complaints, but before we get into that, could you just give us a little bit of information on the difference between a complaint versus a report?
Sure. So information regarding registrants can come to the college by way of two streams. One is a complaint and the other is a report. A complaint is usually filed by an individual who has concerns about the conduct of a registrant. And the complainant is usually the recipient of services provided by a registrant. And the complaint would look into only the concerns that the complainant has identified, even if the college has regulatory concerns that go beyond that complaint. An example of a complaint would be a client who is complaining about fees charged for therapy. And then the second stream is a report, and a report could be filed at the college by way of an individual or an organization who want to bring concerns about the conduct or practice of a registrant to the college's attention. And the concerns raised in a report are usually filed, when they're filed by an individual, they're not usually the recipient of services provided by the registrant. And those types of investigations can look into concerns that go beyond what we would look into in terms of the complaints process. And an example of a report would be from For example, a registrant who has mandatory reporting obligations and has come to learn that another registrant is sexually abusing a client or is incapacitated.
Great, thank you for going through that. So I'll go to Emmett next. Can you go over some of the most common areas that the professional conduct team sees in complaints that are brought forward to the college?
Yeah, so as you can imagine, we really do receive complaints about a wide range of issues. One of the most common practice areas that we see is child custody and access. And these are often complaints involving a registrant who has maybe provided court-mandated therapy or has prepared a report that was used in family court proceedings. And often the complainant is alleging that that registrant was biased against them. Um, Another issue that we do see come up quite often is confidentiality and privacy breaches. So this could be someone complaining that their personal information was disclosed to a third party without their consent. And it could be due to something as simple as an administrative error. And then I did also want to mention that we do receive a relatively high number of complaints each year that deal with sexual abuse and misconduct. And these really are the most serious and high-risk issues that we investigate at the college. And depending on the year, they can account for anywhere between 3 and 5% of the total complaints that get reviewed by the complaints committee.
Okay, thank you. So I'll go back to Beth. If you haven't been able to tell, I'm going to just go back and forth between the two of them. So the college's professional practice team often gets inquiries from registrants who are concerned. They're worried that a complaint is going to be filed against them because the client isn't satisfied with the services provided. Can you talk a bit about the areas that wouldn't meet the threshold of a complaint?
Yes, so there are a few criteria that must be met in order to meet the threshold of a complaint. The first one is that the complainant must identify a registrant. So the college only has jurisdiction over individuals, not organizations. Secondly, with rare exception, the college only has jurisdiction over concerns that pertain to the time frame that the registrant was registered with the college. And thirdly, that the concerns must relate to professional conduct. So, for example, let's say you have a complainant whose landlord happens to be a social worker and that they're unhappy with their rent being increased. This is not something the college would have jurisdiction over. And that brings me to the complaints committee can also decide not to consider or investigate complaints if they do not relate to either the professional misconduct, incompetence, or incapacity of a registrant. And the complaints committee could also deem a complaint to be frivolous, vexatious, or an abusive process. And an example of an FMV complaint would be, for example, if a client complained about the registrant, we investigated it, and the matter went before the complaints committee. The complaints committee rendered a decision, and that complainant is unhappy with the outcome, and so they refile the complaint. This would be a frivolous and vexatious or abusive process. So the committee would likely not look into that a second time. I think that was. Oh, sorry. I was just wanted to add one other point. So the legislation that guides our work, it's the way it's written is it says that the college shall investigate. So the college does not have a lot of discretion around what we can or cannot investigate, unfortunately. So even if the college is obligated to investigate a complaint, this does not mean that the registrants committed any professional misconduct or that the committee will take any action.
Right. Okay, that makes sense. Thank you. So Emmett, can you sort of talk us through the process of what happens when a complaint is filed against the registrant?
Yeah, sure. So when we receive a complaint at the college, the file is assigned to an investigator, and that investigator will typically reach out to the complainant just to make sure that we have an accurate understanding of the concerns that they want us to investigate, and we'll also make sure that we have copies of all the relevant documentation that they have in their possession. And then from there, the registrant is notified that we received a complaint about their practice, and the registrant is either asked to provide a written response to that complaint, or they're informed that maybe we have to conduct a little bit more investigation or inquiries into the matter, and they're asked to hold off on providing their written response until they receive further information from the college. And then once we do collect that information, the registrant will get that information in a subsequent disclosure, and will be asked to provide a response at that time. And I did want to mention that it's not mandatory for a registrant to file a response to a complaint, but typically when we do offer a registrant the opportunity to respond, they are given a deadline of 30 days to provide that response to the college.
So they don't have to respond immediately. They can sort of think about it a little bit.
Yeah.
Okay. And just as a follow-up to that, if someone's filing a complaint, can that complainant remain anonymous, or do they have to say who they are?
Yeah, so we're not able to investigate any concerns that come from an anonymous source. And this really flows from the principles of procedural fairness, and one of which states that the registrant should have an opportunity to fully respond to the complaint that's being made against them. So in our work, that involves knowing the identity of the complainant.
Okay, that makes sense. Yeah. And Beth, another question the professional practice team will often get is, if I'm the subject of a complaint, can I still practice?
Yes, so you can still practice even if you're the subject of a complaint, and the complaints committee cannot revoke or suspend a certificate of registration.
Okay. So Emmett, this is a big one. We're going to do it in a couple of parts, and this also, for anyone who was watching the feature presentation this morning, there were a couple questions that came in about confidentiality and complaints, and I kept saying, watch the afternoon session and you'll get some more information. Yeah, we get a lot of questions about confidentiality. If a complaint is filed against a registrant, and they work for an organization, is their employer informed about the complaint being filed?
Yeah, so the complaints process is confidential, and that means generally we don't disclose to a registrant's employer the fact that a complaint has been filed with us. There are some exceptions, though, that arise. When we're doing an investigation, sometimes the registrant's employer may have information that's relevant for the complaints committee to have. So maybe the registrant's supervisor or manager was a witness to an alleged incident, so we would want to speak to that person and get their evidence. Or sometimes the registrant's employer has access to records that would be helpful for the investigation. So in those cases, the registrant's employer may become aware that we're looking into the registrant's conduct when we make those requests. But we are careful in what we share with the registrant's employer, and they wouldn't receive a copy of the complaint form or any of the particulars of the complaint.
Okay. And following up from that, so you don't inform the employer, do you inform the public if a complaint is filed?
Yeah, so again, because the complaints process is confidential, we don't post the fact that a complaint has been filed on the public register, and members of the public typically aren't entitled to know that information. There are some exceptions, though, that are outlined in our legislation, of course, under Section 50 of the Act. And these exceptions really flow from the college's public protection mandate, and they allow the college to disclose that we're investigating a member in certain situations. So one example would be where a registrant is being investigated for serious professional misconduct, so something like sexual abuse. Then we can provide that information to relevant parties, such as a Children's Aid Society or a law enforcement agency. So again, these sort of flow from the college's responsibility to protect the public.
Yeah, so just the really sort of higher risk. Yeah, okay. And then final follow-up to this question, also in terms of confidentiality, can a registrant share client records as part of the investigation process? If so, how does that work? If not, why not?
Yeah, so this is a question we do receive quite a lot as well. So the standards of practice actually do provide an exception that applies where a registrant is being investigated by the college, and that's section 5.2.5 of the standards. It permits a registrant to disclose information to the college without a client's consent during a college investigation. There's a caveat within the provision, though, that says the registrant should only disclose to the college what's reasonably required. So that means that if we're investigating the registrant for an allegation about something that happened, let's say during a session on a particular date, then the registrant should really only provide records or correspondence that relates to that session. We don't want to receive just the client's entire clinical file, as it could contain sensitive information that really isn't relevant for the college to have access to.
Right. And it's just kept within your, on a need to know basis. It's not going to be
Exactly.
shared throughout the college. I, as a member of not the professional conduct department, would not be privy to these. Yeah. Okay. Great. So we'll go back to Beth. We've got another long question that's going to be split up into a couple parts. So we often hear from registrants who are concerned that their certificate of registration will be revoked due to a complaint. Can you touch briefly on how long an investigation generally takes, and then go over the possible outcomes once the investigation is completed?
Sure. So an investigation can take a couple months up to a year or more, and it really depends on the complexity of the investigation, as well as the potential for risk to the public and the volume of matters we're dealing with at any given time. The most likely outcome at complaints committee is that they'll take no further action, and that happens in over 60% of matters that are reviewed by the complaints committee. The next most common outcome would be remedial advice, and that happens in over 20% of cases that go before the complaints committee. And what that is when the committee releases their decision in writing, it would include some advice to the registrant, for example, on how they could improve their practice. At the next outcome that's possible, it's not as frequent or as likely. It happens in 1 to 3% of the cases, is an oral caution, and that's when the registrant is asked to come before the committee to receive a caution verbally. And then the final possible outcome is a referral to the discipline committee, and that happens in only 1 to 3% of cases. And the remaining cases, there's a handful of outcomes that include the committee determining that they do not have jurisdiction. Sometimes complainants withdraw the complaint. Some are frivolous and vexatious, which I mentioned earlier. Another possible outcome would be if the registrant agrees to sign an undertaking with the college, which I'll touch on in another question later on. The complaints committee is a screening body, and so what they're looking for is just that the registrant has met the minimum requirement standard. They're not looking for perfection. And regardless of what the outcome is, the registrant will be informed of that outcome. The decision and the committee's reasons go out in writing to both the complainant and to the registrant via email.
Okay, great. And follow up to that. So the registrant and the complainant get a copy of the complaints committee's decision. Is the public informed of this outcome as well?
No, the public is not informed of the complaints committee's decisions. However, there are 2 decisions that would be posted to the public register. So one is if a registrant is referred to the discipline committee, that would be noted on the public register. And then the second outcome that would be noted publicly is the undertaking, which I just referred to a moment ago. An undertaking is similar to an agreement or a contract between the registrant and the college. It's voluntary, and it's where the registrant would agree to undertake, for example, some coursework to resolve the concerns raised. And in that case, the terms of the undertaking would be posted on the public register, and then once those terms have been met, that comes off the public register. So otherwise, nothing. The complaints committee's decisions are not sent publicly.
And it sounds like, because you said the referral to discipline was such a small percentage, and undertakings also a very small percentage, that the vast majority of complaints decisions then aren't posted on someone's public register.
Correct.
Yeah. Okay. And then I have a part 3, last part to this question. If either the registrant or the complainant is not happy with what the complaints committee has decided, can they appeal the decision?
The college does not have an internal appeals process.
Okay, great. So I'm going to go back to Emmett. Emmett, you are one of our investigators with the Professional Conduct Department. What does an investigator do? What's your job?
Yeah, so as an investigator, my role is to act as a neutral fact finder. So that means that my work involves gathering all the relevant information that we need for a complaint. So that, as I sort of mentioned before, could include interviewing witnesses or requesting records from a relevant organization or institution. And sort of as sort of has been discussed already, an investigator is not responsible for making any decisions about the outcome of the complaint. That's the responsibility of the complaints committee. So once the investigation is complete, the investigator will compile all the records and information that we've collected and prepare a report that gets reviewed by the complaints committee, and then ultimately they're responsible for determining the outcome and issuing a written decision.
Okay. And you mentioned speaking with witnesses. I know you touched on this very briefly before. Can you just, when you say witness, can you give an example of what a witness might be?
Sure. So a witness would be anyone who maybe has information that's relevant to an allegation. So it could be someone who was present in the room. If the allegation is that, a registrant, maybe made a comment that the complainant found offensive. If someone else was in the room, then it would be really helpful for us to get that person's perspective on what occurred.
Okay, great. So I'm going to go back to Beth. And I now can't remember if it was in Denitha's report or Sanjay's report. I think it was Denitha's report that mentioned that we started an early resolutions process last year. And that this is sort of a way of diverting low-risk complaints away from the formal complaints process. So can you just tell us a little bit more about this program process?
Yes. So it was launched in December of 2025, and now every complaint that comes to the college is screened to see if it's appropriate to resolve by way of early resolution. Some examples of appropriate cases would be a client complaining about some communication issues, perhaps requesting records or appointments being canceled, that sort of thing. And the investigator would review the complainant's concerns and call the complainant and normally just go through confirming what their concerns are, explaining our complaints process, and also explaining the early resolution process. If the complainant's agreeable to attempting to have their concerns resolved by way of early resolution, then the investigator would call the registrant and have a similar conversation. So both parties are sort of informed about what the options are and have to both agree to engage in early resolution. And if they both agree, the investigator is sort of verbally shuttles between the two parties. The investigator would convey to the registrant what the complainant's concerns are and what that complainant is looking for in terms of early resolution. And most commonly, what we find is complainants are really just looking for some sort of acknowledgement by the registrant in terms of what their experience was, and to see if this complaint might, the result might, we often hear complainants say, I just don't want to see this happen to somebody else. So if a registrant, I just want to highlight that if a registrant acknowledges the complainant's sort of experience or feelings, that's not the same as admitting to any wrongdoing. And if the registrant in their response says something like, this complaint, I'll take this into consideration in my future practice. Those are the types of responses that when the investigator goes back to the complainant, those tend to really resolve the matter. And if the complainant is satisfied, then the complaint is withdrawn and the case is closed. So as you can see, it's a lot faster than the complaints process can take, like I said earlier, months to a year or more. The early resolution process sometimes can take a few days to a few weeks. So complainants have been very satisfied with the option of early resolution, as have registrants. Complainants find that they're more engaged in the process. They feel like their voice has been heard and maybe they've made a difference. And they also appreciate just sort of having almost an immediate outcome. And similarly, the registrants are, I think, relieved sometimes just to know that there's an alternate pathway and it's less formal. They're not required to make written submissions. That they don't have to wait months to find out what is the outcome that the complaints committee has decided on. And for the college, it's, it allows us to engage sort of in real time with parties and to be more responsive and more nimble and efficient. It's in keeping with right touch regulation. And often when investigators phone registrants, I've done some early resolution cases, and I almost always they're so scared to get that call, and but by the end of the call, they're saying thank you for reaching out. So, and I hear from complainants, it's so unusual to have like a human phone me. In this day and age, it's a lot of
You're not
email.
AI.
Yeah. So we've since December closed over 20 cases by way of early resolution, and in terms of percentages, that's over 20% of the complaints we've received since December. So it's been very successful.
That's great. And these are just for like the low risk cases. They're like there was an allegation of sexual abuse of a client, for example, that wouldn't be moved into this process.
Correct. We just automatically that would be investigated. So we do sort of triage cases that come in and screen them for the appropriateness of early resolution.
Okay, that makes sense. Thank you. Okay, so we're going to move into our scenarios shortly. Just before we do, just wanted to see any final takeaways, tips, tricks you want to share with registrants about the complaints process. And I'll start with Emmett and then go back to Beth.
Sure, yeah. So I would just want registrants to know that if they're ever subject to a complaint, they're more than welcome to reach out to the investigator that's assigned to their file to ask any questions about the investigation process or the complaints process. But that being said, the college does encourage registrants to consider retaining legal counsel if they're ever subject to a complaint. And that's just because as college staff, we're not really in a position to be able to provide registrants with legal advice and can't really offer any guidance on how they should respond to a complaint.
That makes sense. Beth?
Yeah, and I'll add that, like I said, I just want to acknowledge how scary it can be to receive a complaint, to be the recipient of a complaint, and anyone could complain about anyone at any given time. And like I said earlier, the college really doesn't have a lot of discretion about what we can investigate or not. And in terms of numbers, there's over 34,000 registrants in the province, and we receive approximately 320 complaints a year. So that's less than 1% of the registrants will receive a complaint in any given year. And over 60% of those that go before the committee the outcome will be a take no action. So I hope that helps.
So it's like a tiny, tiny, tiny percentage. Great, thank you. So we're going to go through a few scenarios, and this, again, will hopefully alleviate some concerns to see what the complaints committee may typically decide to do. So again, we're going to be using Mentimeter, and if you could see on your screen, you can either go to www.menti.com and enter in the code that's there, or you can scan that QR code. And I'll just give it a second to make sure that everybody watching at home can see the screen, and then we can move into our scenario. Okay, I'm seeing some thumbs up, so hopefully that means okay, lots of thumbs up. Great. Okay. All right. So we'll get into our first scenario. And just a note, the question that we're going to be asking for each of these scenarios is the same question for each one, just to sort of get a flavor of some of the different things that the complaints committee may see. So here we go. An individual booked an initial intake session with a registrant, and this session was to take place virtually on a video conference platform. So the individual accessed the meeting link at the scheduled time, but the registrant signed on 5 minutes late and did not acknowledge that they were late or apologize for being late. After this intake session, the individual decided not to move forward with seeking further services from the registrant And they also filed a complaint with the college as they were upset that the registrant was late and did not apologize for their lateness. So what do you think is the most likely outcome for this complaint? And your choices will be, we move to the next slide, we should get, so either the complaints committee decides to take no action, provide the registrant with advice, require the registrant to appear before the complaints committee for an oral caution, or refer the matter to the discipline committee for a hearing. Ooh, this is fun, watching the watching everything come in. So I'll just give it a minute or two to allow people to answer. It looks like a little bit of a race between take no action and provide the registrant with advice. It's sort of like watching one of those horse races where one like sort of edges out the other. Oh, it's very close. Interesting. Ooh. Oh. Providing the registrant with advice has got a slight edge now over take no action. We're seeing very little require the registrant to appear before the committee for an oral caution or refer the matter to the discipline committee for a hearing. I think we look pretty stable. Okay, so I think, Emmett, are you gonna take this one? It's very interesting.
Yeah, these are interesting results. So the answer we were looking for here was take no action. And the reason for this is really being like 5 minutes late for an appointment doesn't really rise to the level of professional misconduct. The reason we included this scenario was also to highlight that this would be a really great candidate for early resolution. So if in speaking with the complainant, the investigator was sort of getting the sense that really the main concern that they have is that the registrant didn't acknowledge that they were late and they didn't receive an apology, then that's something the investigator could probe with the complainant and see if they would be interested in resolving their concerns through early resolution. And then if both the registrant and complainant agreed to proceed, we could divert this matter from the investigations process and the matter would be withdrawn if assuming the registrant did obviously provide that apology and the complainant was satisfied with that. But if this were to go through an investigation and go to the complaints committee, it would likely be a case where there would be no action taken by the committee.
Right, and it might be different if this was an ongoing lateness issue as opposed to just that one first session. Yeah. Sarah, I'm just curious, are you seeing anything similar in the chat or have most people put their responses into Mentimeter?
I think everybody's using the Mentimeter in terms of providing their feedback there, so that's great.
Okay, perfect. All right. All right, so I think we can move on to our second scenario. So we have a social work student who is completing a practicum placement at a hospital. And the student feels that their placement supervisor treats them rudely and is very demanding in their requests. Additionally, the student does not feel that their supervisor is providing them with adequate supports to properly complete their practicum duties. And the student files a complaint with the college. So again, what is the most likely outcome for this complaint? Do you think the complaints committee would choose to take no action, provide the registrant with advice, require the registrant to appear before the complaints committee for an oral caution, or refer the matter to the discipline committee for a hearing? Ooh. I feel like the take no action from the first scenario is gonna skew people going forward, maybe if they thought it was take no action before. All right. Okay. So provide the registrant with advice seems to be winning quite handily with hovering around 70%. Take no action is growing though, 22%. And then a distant third require the registrant to appear before the complaints committee for an oral caution and then 2% refer the matter to the discipline committee for a hearing. So Beth, it looks like 70% have said provide registrant with advice. What do you think?
I think you're right. We wanted to include this question just to highlight that the student does meet the definition of a client. Therefore, this complaint would fall within our jurisdiction, and it would likely see the registrant receiving some advice.
Great, thank you. So we'll move on to our third scenario. I'm going to read out the first part, and then I'm going to get Sarah to flip the slide to the second part. So we have a concerned parent who files a complaint with the college after finding out that their 15-year-old child has been seeing a registrant for counseling services. And this parent is very upset because they have joint decision-making authority with their ex-spouse, but they were not consulted as to whether their child could go to counseling. And then if we could get to the second part of the slide.
I've just had some feedback that some registrants are wanting more time to review the scenario. So maybe I'll ask you to read it a second time just to allow everybody to sort of absorb the scenario.
Of course, yeah, no, that makes sense. Okay, so we have a concerned parent. They're filing a complaint with the college. They've just found out that their 15-year-old child is receiving counseling services from a registrant. They have joint decision-making power with their ex-spouse, but they were not informed that their child was seeing the registrant for counseling services. And then if we move on to the second part, so when they found out that their child was seeing the registrant, the parent contacted them to indicate that they did not provide their consent for these services, and they ordered the registrant to stop seeing their child. In the response, the registrant explained that the therapeutic relationship was helping the teenager process their parents' divorce, and that as long as the child wanted to continue the relationship, the registrant would still provide services. So again, we have a parent who has been divorced from their spouse. They share joint decision-making powers, but their 15-year-old child has been seeing a registrant for counseling services. The parent, one parent at least, was not informed. They are upset because they did not provide their consent. So they contact the registrant, and the registrant says, well, I'm going to continue seeing your 15-year-old child regardless. So hopefully that's good. We'll move on to what the complaints committee might decide here. So again, our choices are take no action, provide the registrant with advice, require the registrant to appear before the complaints committee for an oral caution, and refer the matter to the discipline committee for a hearing. Okay. All right. So we've got, all right, take no action, hovering around the halfway percentage point with a second place of providing the registrant with advice. And, oh, interesting. This is the highest one we've had so far with referring the matter to the discipline committee for a hearing. 7%, it's still at the bottom, but, and 16% requiring the registrant to appear before the complaints committee for an oral caution. Okay. Take no action is still, it's dropped a little bit. It's a little bit under 50% now. We've got 45% with 30% providing the registrant with advice, 31%. Ooh, okay. Seeing a lot of thumbs up. I'm not sure if that means they're agreeing with the choices or not. Yeah, it's very suspenseful. Okay, so I think we're landing on 43% take no action, 31% provide the registrant with advice, 19% require the registrant to appear before the complaints committee for an oral caution, and 7% refer the matter to the discipline committee for a hearing. So, Emmett.
Yeah, so this one's quite controversial.
Yeah.
So the correct answer here, or what would be the most likely outcome, would be that the complaints committee would take no action. And that's because in this scenario, there's no professional misconduct that's occurred. So because the child here is 15 years old, given their age, they had the requisite capacity to consent to the services being provided by the registrant. So regardless of any decision making that the complainant had, the registrant was correct in continuing to provide the service.
And we're assuming that the 15-year-old is competent and able to make their, to consent. I'll just mention we did recently update our practice guidelines on consent and confidentiality with children and youth. And that can be found in our resource room on our website, as well as a handy Q&A document around that. So it's always a really interesting topic of conversation. So yeah, okay. All right. So we've got a couple more scenarios. So we'll move to 4. So we have a registrant. They're closing their practice because they're moving out of province. And they inform their clients by email that they will be closing their practice and provide a list of other service providers that their clients may want to reach out to for further psychotherapy. One of their clients files a complaint that their therapeutic relationship was terminated without notice. So again, a registrant is only able to practice in Ontario. They decide to move elsewhere out of province, and they decide they're not going to seek registration in that province or electronic registration here to continue seeing their clients virtually. And they tell their clients via email, I'm moving. Here's a list of other people you may want to see to continue your therapeutic relationship. And one client is unhappy with that, feels that their therapeutic relationship was terminated without notice. So what is the most likely outcome for this complaint? And again, we have take no action, provide the registrant with advice, require the registrant to appear before the complaints committee for an oral caution, or refer the matter to the discipline committee for a hearing. Ah, wow. Take no action is winning the horse race for sure. Interesting. All right. Provide the registrant with advice is growing slightly, but it hasn't quite hit even the halfway point before to the take no action. And then again, the oral caution and the referring the matter to discipline are quite low down, which again sort of reflects what actually happens, right? Like as you said, Beth, what is it? 1% to 3% are referred to the discipline committee.
Yes.
Yeah. So it's a pretty low number. Okay. Interesting. Okay. So we've got take no action won by quite a lot with 70%. And then 23% provide the registrant with advice. And then we drop way down to requiring the registrant to appear for an oral caution at 5% and only 1% referral to discipline. So, Beth.
Yeah, so we, on the face of this, it sounds like the registrant was reasonable and did what we would expect. We wanted to use this scenario to highlight that we do have a standard around termination, and it does include that the registrant also takes reasonable efforts to hold a termination session with the client and provide an explanation for discontinuing the services. So this is a scenario we see quite frequently. So even if a registrant, believes they're doing everything on the up and up, we just wanted to highlight that it is important to offer that termination session, and that's even if the client themselves were the ones that initiated the termination. So this situation would probably see the registrant receiving some advice on following the standard.
Great, thank you. I feel like we've skewed everybody by saying most complaints go to take no action. So we can move on to our final scenario. This one's a little bit complicated, so I'll go through it a couple times and I'll hopefully speak slowly. So we have at a friend's party, a registrant is striking up a conversation with someone they've never met before. So let's call this stranger Bob. And the registrant's speaking with Bob, and they realize, oh, Bob is cousins with one of my clients. My client's name is Joe. And the registrant in this conversation mentions to Bob, oh, Bob, I see your cousin Joe for psychotherapy services. So I have this great family connection. Isn't that wonderful? Yes. So, yeah. All right, so hopefully that's clear. We have registrant who I didn't name. We can call them Haley. Okay, registrant Haley. I'm not a registrant. I'm the registrant. I meet Bob, and I speak with Bob, and it comes out Bob is cousins with my client Joe, and I mention, Bob, I see your client Joe for psychotherapy services. So hopefully we've got the parties figured out. So then Bob and Joe are at a family gathering, and Bob goes to cousin Joe and says, oh, hey, Joe, I met your therapist at a party the other day. They seemed really nice. And Joe is quite upset. They had not disclosed to anyone in their family that they were seeing a therapist. And now that Bob has said this to them, it's just spreading throughout the family gathering. We all know, I mean, maybe not all families are like this, but I feel like most families, information spreads quite quickly. And so the client, Joe, being very upset, files a complaint with the college over this breach of confidentiality. So again, I've just touched my microphone. I hope that wasn't too loud, sorry. I'm the registrant, and I've met Bob, and I've told Bob that I see his cousin Joe for psychotherapy. And Joe is not happy to find out that I have told Bob this information. Okay, so again, we have our 4 choices. We have take no action, we have provide the registrant with advice, require the registrant to appear before the complaints committee for an oral caution, and refer the matter to the discipline committee for a hearing. Okay, interesting. We have 0% take no action this time. All right. And we have refer the matter to the discipline committee, so far winning with just over 50%. And then the oral caution coming in at number 2, with provide the registrant with advice quite low down, and then take no action at just 1%. So we'll give it another couple minutes, see what's coming in. Again, lots of thumbs up, so I think that means that people are happy with these choices. We'll see. Still a little bit, it's pretty stable. I feel like it's going to stay at over 50%, refer the matter to the discipline committee for a hearing, and then second, require the registrant to appear before the complaints committee for an oral caution. So, Emmett, what do you think?
Can I just see Sarah maybe has something to jump in?
Yeah, go ahead.
I wanted to jump in and ask a question that we've been getting throughout these scenarios that I wonder if Beth and Emma might be able to clarify. So when you're talking through take no action, registrants are wondering what the difference is around the early resolution, Beth, that I know you had mentioned. So if we identify take no action in the other scenarios that we were looking through, does that mean those complaints may be a good opportunity for that early resolution piece instead?
Yes, I think it's a matter of sequencing. So first we would receive a complaint, and it's at that very early stage of the complaint where staff will screen it and triage it to see if the complainant might be willing to engage in early resolution. If the complainant is not willing, and some are not, and they say, no, I want this investigated, then that's where those types of matters would go through the complaints process. They would be investigated. The matter would go before the complaints committee, and they would likely result in a take no action.
Yeah, and it's a fairly new process, right? So I have to wonder if, as time goes on, perhaps more complainants will be familiar with it and become comfortable, and perhaps more may decide to go down that route. I mean, who knows? Yeah. That clarifies? Yeah? Okay, great. So for this one, yeah, we're still sitting at just over 50% referring the matter to discipline for a hearing, with the oral caution close second.
Yeah, so maybe surprising, the answer we're looking for this one would be likely provide the registrant with advice. There's a possibility that this could also result in an oral caution depending on the facts of the case. So depending on how the registrant responded to the breach of confidentiality and sort of any reflections that they provided in their response. But also whether the question would be asked is this the first time that we've received this kind of complaint about this registrant? If it's not the first time, then that sort of progressive next step would be to take this from providing advice to the registrant to perhaps going the route of an oral caution. And another reason we wanted to include this scenario was just to highlight that the issue here really is the breach of confidentiality. It's not anything to do with any sort of potential dual relationship. The college and the standards do sort of recognize that for registrants, especially those living in smaller communities, they might find themselves in these sort of situations, where they're becoming acquaintances with people in the community. And we encourage registrants who sort of find themselves in that sort of situation to consult the standards or seek supervision or consult professional practice.
Yeah, okay. It's very interesting because myself as a non-registrant and as someone who's not on the complaints committee, my immediate response was also, oh, this would go to discipline. But yeah, if there's no previous complaints, and if the registrant realizes, oops, I was in a social party atmosphere, and they're quite apologetic. And
like Beth said, all of the decisions that are referred to discipline are posted on the website. So registrants may find it helpful to go on the website and review the decisions of the discipline committee, and that sort of can give you a sense of the types of cases that go to the discipline committee, and they are really sort of the most serious issues that we investigate.
Right. Yeah, no, that's a good tip as well. Yeah, all the notices of hearing are notices of hearings, I guess it would be plural, are posted on the college website. Okay, great. So I think that brings us to the end of our conversation. Thank you so much for sharing your insights. Very interesting. I hope registrants got a lot out of it. And I think we have some time for questions. A reminder, you can write your question in the chat on the right-hand side of your screen. And those watching on phones or tablets likely won't have access to that feature, unfortunately. And I'll just get Sarah to read them out.
Thank you so much. So we've had a few questions come up throughout the presentation. I'll ask one fairly straightforward. Is how are complainants notified of the process when a complaint is filed against them? So sort of talking about from a practical standpoint, is it an email? Is it a formal letter? Is it a phone call? What does that look like?
Yeah, so when we're letting registrants know that we've received a complaint about their practice, they get an email from the investigator, and there's a letter that's included with that email that sort of outlines the complaints process, and it gives them a little bit of information about the complainant and the steps that we've taken so far in order to gather information, and it outlines the information sort of that I spoke about earlier about the deadline for their response. It talks a little bit about how it can be useful to retain legal counsel to assist with navigating the process and preparing a response. So all that information comes in a letter that is sent to the registrant by email.
Great. Thank you for that. We received a question around if someone agrees to withdraw the complaint, and they're specifically asking if it's going through the early resolution and they agree to withdraw the complaint, are they then able to resubmit if they change their mind at some point?
Yeah, that's a good question. And they can resubmit the complaint, and it's I would go through this on the phone with the complainant and the registrant in a real life situation, to be in terms of just being completely transparent and full disclosure. I often say that the early resolution, it's informal, And so it's really on the honor system that we're trying to resolve the concerns of the complainant. And we sort of ask that the complainant engage with that, keeping that in mind. And we also do tell the registrant when we phone them to go over their options, that that is one downside of their early resolution, is that the complainant could turn around and say, you know what, I want this investigated either now or, in a few months or a few years. There's no statute of limitation. So that is one chance that the registrant might be taking. Unlike what I said earlier about that, if a complaint goes to a complaints committee, it's been investigated, a decision is rendered, that's a final sort of end to the process. That complainant can't come back and try to have something reinvestigated that's already gone before the complaints committee.
Thank you. We also received a question around just maybe reminding folks about the outcomes that are made public. So when we're talking through complaints and discipline processes, so is it only the outcomes from a discipline committee that gets made public, or are those remedial advice or oral cautions also made public?
So the only outcome from the complaints committee that's made public would be a referral to the discipline committee. And then the other situation I talked about, which is a very small percentage of cases, is where the registrant is voluntarily engaging in formalized remediation by way of an undertaking with the college. So that's something that the registrant would have to, and they would voluntarily agree to undertake to do that sort of remediation. And that's something they would engage in. They would know at the time that that's part of the undertaking, that the terms would be posted until the terms have been met. So any of the other outcomes we went over, from no action, advice, oral caution, those are not posted publicly.
Thanks for that, Beth. We did receive a question that's related to title protection matters. So wondering what that process is, and I'm happy to share links as well on the website, but wondering if someone can maybe touch on questions around filing complaints about someone who's identifying themselves as a social worker, social service worker, but is not actually registered with the college.
Yeah, so those don't go through the complaints or reports process. They go through a separate title protection process. So there's another staff member at the college who's responsible for sort of dealing with those complaints, or reports rather. And I'm not super familiar with the process. I don't know, Beth, if you want to jump in a little bit about how that goes, but
Yeah, I was going to say that it's not something that would be a complaint or go before the complaints committee. And we do have somebody who monitors and follows up on those reports. And on June 24th, there is going to be a coffee time with the college, and we're going to be talking about a little bit in terms of conduct that involves other things beyond just the complaints committee process. So you can tune in for more then.
Thank you for that plug-in. I'll also post a link for the Coffee with the College registration date. And I did also add in the unregulated practitioners webpage that we have on the website. As Emmett and Beth noted, we have lots of information there. So thank you for that. I'm also just going to add in some comments while questions are coming through. We're getting lots of positive feedback around the scenario and the discussions that took place today, and individuals and registrants really appreciating that. So a question about what would the process look like if registrants have a concern regarding their employer. So when it comes to who is also a registrant, so both registrants and their complaints is around the management or employer conduct. Wondering if you might be able to touch base on how that would work.
yeah, so typically the college it doesn't really have the jurisdiction to investigate concerns that are really at their heart an employment issue. So if it's something about, my organization hasn't paid me, or not receiving adequate supervision, that's really an employment issue, and we would direct the registrant to raise those concerns within their organization. But sort of like the scenario that we had, where there is sort of a professional conduct aspect to the registrant's concerns, then the college does have the jurisdiction to investigate. So there are standards um, in the standards that speak to, sort of professional conduct and civility, and those are sort of things that the college could investigate. But generally, if something's falling within the employment realm, we would encourage registrants to sort of first try to resolve those concerns with the employer directly.
So if it was about wages or your work schedule or vacation time or something, that wouldn't be something.
Yeah, and I would add that this was kind of focusing more on complaints, and that's something like Beth was talking about. That would be more so something we would address in the report stream.
Right. Okay.
We have a question that I think relates to one of the scenarios where there was that 15-year-old receiving counseling services. So clarification question around the investigation process in itself. So how is confidentiality managed if the parent files a complaint related to services that were provided to the adolescent? Are files shared in terms of disclosure with the parent who made the complaint, and how that confidentiality sort of works?
So, just to be clear, is it the child's record, and would the registrant provide it to the college?
Yeah, so I think the question is around the record and whether the parent would end up gaining access to that through sort of the disclosure of information.
No, the information would only be disclosed to the college, and we don't disseminate that information anywhere else.
Yeah, so the complainant would get the complaints committee's written decision, and sort of the decision doesn't attach the record or anything like that. It might sort of speak to if there was particular information in the client's record that was really useful to the committee being able to dispose of the matter. Then it might sort of refer to it. But again, they're sort of cautious about the information that's shared in the decisions with these sort of issues in mind in terms of keeping the confidentiality of third parties to the complaint.
And I can't remember the number of the specific standard of practice that you quoted before, but it's only the relevant information that would need to be shared for the client record. For something like this, and maybe I'm overstepping, but I would imagine it would just be the conversation about whether or not the 15-year-old has the ability to and understanding to consent. It wouldn't be all of their
so in the decision, like the
record.
committee might comment on the registrant's notes demonstrating that they did have that conversation with the child, but they wouldn't disclose the records themselves.
Okay, I think we have time for a few more questions. Can someone file a complaint against a registrant who's acting in a voluntary capacity? So in a volunteer capacity, so not necessarily their place of employment.
I mean, like I said earlier, anyone could complain about a registrant. Whether or not that would be considered frivolous and vexatious would be something that the complaints committee would consider.
Yeah, and it would kind of hinge on whether the registrant in that voluntary position was providing services to the complainant and whether there was a client relationship. If there wasn't a client relationship, like let's say I don't know, it was just a volunteer event and the complainant was upset about the way that the registrant conducted themselves while they were volunteering together, that would probably be something that would go under sort of the frivolous or vexatious heading. But yeah, if it was about you're providing sort of pro bono services to a client, then the college would have jurisdiction to investigate that.
That's helpful. Thank you. A question going back earlier in the conversation, sort of more in the introductory part of today's discussion, around when complaints are filed, whether an employer is told. And I know, Emmett, you sort of talked through, there may be opportunities where an investigator may need to get information or access to information that an employer would have. So just wanting to get some clarification around whether a registrant would have an opportunity to reach out to the employer ahead of time, or if it's sort of a cold call that happens from the college to the employer and what that looks like.
It kind of depends on the situation. If we're trying to get information from a witness, we wouldn't necessarily want to have the registrant have the opportunity to kind of give advance notice to that witness that, hey, they're going to be calling you, because that could kind of create a situation where we may not be getting the best evidence from that witness. But if it's something like records, it kind of depends. Sometimes a registrant, in providing their response to the college, maybe they no longer work for an organization, so they can't access the relevant records, but they need the request to come from the college. So in those sort of situations, the registrant may be able to sort of give their employer the heads up, hey, someone from the college is going to be requesting records. But it kind of depends on the situation.
Okay, we had a question from a registrant just sort of acknowledging and talking through the realities in not-for-profit work, and how it is common for registrants, so social workers or social service workers, to feel overwhelmed with work and then give just only 2 weeks notice. And so there's not always the opportunity for them to provide appropriate termination sessions. So the question around that reality is, if a complaint was filed, how would you what would be the potential way of handling a complaint? So if a registrant is no longer working for that not-for-profit organization, they did not provide a termination session.
That's a good question. I think that it's like many things, each case can be nuanced, and we have to look at the specific facts of a situation. And I don't know what role the organization would play in terms of offering that transition of client care to somebody else in the organization. I don't know if Emmett has anything to add.
Yeah, I think, and maybe correct me if I'm wrong, but I think the standards speaks to sort of the reasonable efforts. So that would be something the committee might take into consideration, and sort of moving that from being something that might require advice to perhaps being a take no action, or just sort of a light touch, kind of like, this is something to keep in mind. But it sort of hinges on the registrant's response and the context that they provide, but comes down to those reasonable efforts.
It might be different in that situation versus if you have your own private practice and give a week or 2 weeks notice.
That's great. Thank you. There is a question around the discipline process. And so I'm happy to sort of provide and sort of defer to the website, where I know there's lots of information, but I am going to say this out loud as well. So talking through registrants who are found guilty of misconduct, are they removed from the college? So I think they're talking about revocation. And so just maybe talking through really briefly possible outcomes from a disciplinary process. And I'll also share the link on the website so we can kind of direct people to that.
Yeah, I mean, that kind of that's sort of where some complaints end up after they go before the complaints committee, if they're referred to the discipline committee and there's a hearing, and it's say some are contested and some facts are proven. Possible outcomes can range from revocation, suspension, reprimands,
Terms, conditions,
yeah, restrictions, paying, reimbursing, that sort of thing.
We're putting you on the spot for that. So thank you. I have shared all the information, our discipline webpage that we have, which outlines information. I'm not seeing any new questions come through, and I know we're close to coming to an end. So I think I'll throw it back over to you, Haley.
Great. So thank you both so much for sitting down and chatting and going through all of these really very nuanced situations. And I know that Sarah and Beth both mentioned it, but again, Beth is going to be at the next Coffee with the College, which is June 24th at noon. And so if anyone has more questions about complaints or the other parts of the professional conduct, including title protection and discipline and all the other areas that they cover, I'd encourage you to sign up for that. It's free. Professional practice staff will be there as well, and they'll be able to answer practice questions. So it's a really great resource. And yeah, that's noon to 1 p.m. on June 24th. Yes. Okay, so I think that concludes everything. We have a couple minutes, and then we're going to reconvene at 4:20 for the day's closing intention with Ron Knudski, and I hope that you all stick around for that. And again, you can access the closing intention through the Sessions tab. So thanks so much for watching, and to Emmett and Beth for being here.